Yes, please.
Can go on?
Where's the notebook? I made a notebook. Yes, please.
This is the yesterday's matter, my lord,
Yes.
pertaining to LASIK surgery.
You want to make some submissions? Make submissions. Otherwise, file notes.
But the only submission, what I've been told, my lord, because there is a emphasis on recruitment of female officers
Yes.
and in paramilitary forces also, my lord, and these nurses have to accompany the
Lateral. Otherwise,
my lord. And this nursing staff, they accompany the troops, my lord, the female troops on patrolling duty also.
doctors also do so.
Doctors, they don't do so, my lord. Maybe sometimes in emergency cases they do so, my lord. But normally on patrolling duty, female nurses, they accompany the troops, my lord. And in the meantime, I'll file my written notes, my lord. You'll have to kindly grant
You want to
some
make submissions?
Your Lordship, the London Single Judge has rightly said, Your Lordship, that there is a discrimination. Rule 67 is discriminatory, Your Lordship. And Your Lordship, the respondent herein was initially applied for staff nurse, which
Where is Rule 67?
page 133 of the paper book, Your Lordship. Your Lordship. Also, Your Lordship, the respondent herein applied for staff nurse, which is equivalent to Naib Subedar, Your Lordship. I have confirmed yesterday, Your Lordship. And after the LASIK surgery, Your
1
Lordship.
minute. These are policy guidelines on visual standards.
Yes, my lord.
Yes.
Page 105.
Yes, Your Lordship.
And this is the schedule you showed,
My lord.
Dr. Bozika.
Page
Page
112.
112.
Yes, my lord. And this is applicable to SO, my lord. SO is subordinate officers, my lord. Subordinate officers, and OR is other ranks. Just above the table, my lord, it's a visual standard for direct entry, SOs and ORs and CAPFs. just above the table, page 112, my lord, table 3, visual standards for direct entry, SO and OR. Lordship will see at page 113, my lord, on the next page. It's a table 4, my lord. Page 113. Table 4, my lord. This is what tradesman follows. Similar standards input. Visual correction of any kind is not permitted.
Page 11.
113. Table 4, my lord. In table 4, your lordship will see there are two categories, my lord. In refraction, my lord, it says visual correction of any kind is not permitted for distant, but should be able to read with glasses for near vision only. And tradesman include cook, washerman, barber, tailor, bookmaker, carpenter, etc. Some relaxation will be given to them, my lord. Lordship may correlate this with page 111, my lord, table 1. Table 1, my lord. This is visual standards for direct entry gazetted officers and CAPFs. And in the last column, my lord, it says third LASIK surgery correction is permitted subject to prescribed criteria mentioned in table L. And again, table 2 also, below table 1. This is about doctors. The LASIK is permitted in table 2. Just below table 1, table 2 is other gazetted officers like medical officers, specialists, super specialists, dentists, veterinary officers, so and so. In the last column, my lord, the LASIK surgery correction is permitted subject to prescribed criteria mentioned in table L. My lord, in my humble submission, my lord, to sum up, my lord, due care has been taken as per the requirement of the post, my lord, and criteria has been let down accordingly.
This is in which service?
In Assam Rifles, my lord.
To the post of staff nurse, your lordship.
Recruitment to the post of staff nurse in Assam Rifles.
Staff nurse.
Yes, your lordship.
How many posts were there?
Total, your lordship, only 18 posts was floated, your lordship. One post was for the Rajasthan in general category, your lordship, which I applied.
One post was for?
Rajasthan quota, your lordship. And I applied for
Because
that
in
quota.
paramedic also, when posts are advertised, my lord, number of posts are allocated state-wise, my lord. Well, page 17, your lordship will find that, my lord.
One seven.
1-7. There's a table given, my lord. So that's how the posts are allocated, my lord, category-wise, SC, ST, OBC, and to different states, my lord. Just to maintain the pan-India character of the force, my lord. Stop this page.
Staff serial number,
Page 17.
serial 29. 29. Sir.
Fifth column, my lord, at page 17. This
Yes.
was staff nurse.
So this must be vacant up to now.
There's a direction to keep it vacant, my lord, with the learned single judge at the motion stage. Once it was that vacant.
Your Lordship, Your Lordship, if I may, Your Lordship, the advertisement is silent about the non-undergoing of the LASIK surgery, Your Lordship. The advertisement, you'll find it in page 24, Your Lordship.
Single WPC order.
There is a table, Your Lordship, point number 4, page 24, Your Lordship. Number 4 is the advertisement for staff nurse, Your Lordship. After this advertisement, Your Lordship, I filed my application, Your Lordship. Thereafter, after clearing the written examination in the medical board, Your Lordship, due to the defective vision, Your Lordship, I was rejected. Your Lordship, after the rejection, Your Lordship, one of the doctor recommend for LASIK treatment and to get another fitness certificate in Form 3, Your Lordship. Thereafter, my vision was recorded 6 by 6. And thereafter, I submitted the same to the review medical board. They rejected me on the sole ground that since there is only scar seen, Your Lordship, that's why I was rejected, which you will find it, Your Lordship.
Where is the rejection decision?
Your Lordship, page 34, Your Lordship. 34. Your Lordship, in final opinion, Your Lordship, LASIK scars seen in both cornea, Your Lordship. However, the vision recorded, Your Lordship, it's 6 by 6 in both the eyes. And the reason given, Your Lordship, it's B, 3B, unfit on account of post-LASIK scar, both eyes, Your Lordship. Thereafter, we challenged, Your Lordship, and the learned single judge was pleased to struck down Rule 67. It's violative of Article 14, Your Lordship. The appellant here, in Your Lordship, has not rightly placed, Your Lordship. It is not as per intelligible differential, Lordship. Since doctors and nurses' work is almost the same, Your Lordship. Rather, the work of the doctor is more comprehensive. The doctor performs surgery, Your Lordship, whereas staff nurse only assists the doctors. Hence, it is violative of Article 14, Your Lordship. Your Lordship, yesterday it was suggested, Your Lordship, that a bracket may be put in the Rule 67, Your Lordship, for staff nurses also, Your Lordship. Your Lordship, if I might take you to one page, Your Lordship, that is the acknowledgement of this guidelines, Your Lordship. Page 47, Your Lordship. Page 47, Your Lordship. May I read, Your Lordship?
Yes.
Para 2. The medical fitness criteria have due allowances for the age of the candidate, yet...
Page 47.
Yes, Your Lordship. Of the paper book, Your Lordship. Lordship, have it? The medical fitness criteria have due allowance for the age of the candidate, yet it should be understood that the question of fitness involves fixed future as well as present, and that one of the main objects of medical examination is to secure a continuous effective service and to prevent early pension or payment due to premature discharge from service or death. The instructions of medical examination had been issued by MHA for assistant commandant, sub-inspectors and constable in CAPF separately and have been amended as and when need arose, Your Lordship. This line is important, Your Lordship. CAPF separately and have been amended as and when need arose, full stop. During past, there have been court judgments, Your Lordship, which were overriding the existing instructions. The medical advancement has also brought a treatment technology to a stage where a disease or disability is curable to normal functional status. A need to revise and redraft the medical examination guidelines is a more exhaustive and illustrative manner and encompassing the future of advancement in medical technologies was felt, and thus a board of specialists and experienced medical officers from CAPF were constituted under the chairmanship of Dr. Mukesh Saxena, so and so for the purpose. Your Lordship, here in their acknowledgement, Your Lordship, they have relied, Your Lordship, that during there are certain court judgments which were overriding and their need aroses, Your Lordship. Here also, Your Lordship, since the doctor and nurses staff is almost identical, Your Lordship, so if they can amend these rules, Your Lordship, they can put the staff nurse, they can exempt, Your Lordship, as similar to doctor, Your Lordship. If doctor is allowed for LASIK treatment, why not the nurses, Your Lordship? It is in their domain, Your Lordship, which they can do, Your Lordship. Since the nurses does not perform the surgery, Your Lordship. And since the respondent herein, Your Lordship, she was directly into the staff nurse, which is equivalent to Naib Subedar, not a rifleman, Your Lordship. In emergency situation also, Your Lordship, she will not be sent to war, Your Lordship, if the need arises, Your Lordship. Hence, in my humble submission, this appeal may be dismissed, Your Lordship.
You wish to add anything? You see, the problem with your notification is you come to the schedule which relates to drivers, cooks, etc., etc. They are permitted to be recruited with reading glasses.
Yes.
If they are long-sighted, or that means their distant vision is all right, then it is okay.
Yes.
If the short vision is defective, you can operate with glasses. But as far as nurses are concerned, blanket prohibition. How do you justify that? Group 4. You see the last column?
Yes, 112. 130. Cook, washerman, tailor, bootmaker, carpenter, they are allowed, madam.
For drivers, etc., who drive vehicles, long-sightedness is essential.
Yes, madam.
You can't be short-sighted because you will miss targets. But for nurses, it should have been the opposite.
So let's say we'll issue a direction to review this part, my lord, to the competent authorities to take into the
You see
observation.
what the little mistake we are making.
My lord,
This is a policy matter.
my lord,
This is not statutory.
my lord.
This is an administrative policy. We are saying you do this, do this, do this, do this, do this, don't do this, etc.
Well,
So we can only say that with reference to nurses, this kind of thing will be disapplied, or the criterion with regard to drivers, cooks, etc. may be applied. That's all.
well,
There is no question of striking down anything because this is not legislation.
my lord,
This is a policy matter.
Well.
These doctors follow as a kind of a protocol.
my lord.
So we will say you apply the rules or the medical fitness criteria with regard to that group 4 people, with regard to nurses also, and don't apply the paramilitary criteria
Well.
for nurses. But it appears that in spite of LASIK, you have defective vision.
No, Your Lordship. After LASIK, my vision is corrected, Your Lordship.
No, you see the report. That will go against you. You have to be medically fit. LASIK will not do.
Page 34, Your Lordship.
Page
34, Your Lordship. Serial number 2. Your Lordship.
reason for medical unfitness. Not that you have undertaken LASIK. Defective distant vision. That is the reason.
Your Lordship, point number 2, Your Lordship, if you would. Brief of review medical examination and finding thereof.
Yes, LASIK scar seen in both cornea.
Above that, Your Lordship, 6/6 right eye, 6/6 right eye, Your Lordship.
That is the power.
Now, Your Lordship, after the surgery, before it was 6/12, Your Lordship. Before it was 6/12.
We are not concerned with 6/12. We are concerned with the remark.
Your Lordship, now it's 6/6.
LASIK scar seen in both cornea. They are not saying because of LASIK we are not taking you.
It's just for scar, yes, Your Lordship.
It's a scar.
Scar, only for scar.
That is the after effect of the surgery.
Yes, sir.
Yes.
Yes, Your Lordship.
And over that they are saying defective distant vision.
Your Lordship, that was the earlier ground.
Unfit on account of post LASIK scar.
Both eyes, only for scars, Your Lordship. Your Lordship, the reason number
They
1.
are not saying because you have undertaken LASIK.
It's just for scar, Your Lordship. Post
Yes.
Yes, Your Lordship. I
That
admit.
is maybe a failed surgery.
Your Lordship, but the reason number 1, Your Lordship, defective distance vision, it was for the earlier one, Your Lordship. It was for the earlier one, Your Lordship.
But earlier one means what?
Before the LASIK treatment, Your Lordship, my vision was 6/12. So this was the reason for that, Your Lordship. However, now the vision is all right, Your Lordship. It's only, they have rejected me only on the grounds of LASIK scar, Your Lordship.
They are saying reason for medical unfitness, defective distant vision.
Your Lordship, that is prior to LASIK.
Where do you get prior? Where do you get this? Prior and post?
Your Lordship, I'll come to that. Your Lordship, have it page 30, Your Lordship. This was after the written examination, the first medical, Your Lordship.
Unfit.
Yes, Your Lordship.
What is the date?
4th May 2018, Your Lordship.
Where do you get it?
On top, it's written, Your Lordship. above summary of medical examination.
The next is page 34, 8 June.
8 June, yes, Your Lordship.
So what is prior and what is post?
Your Lordship, in 4th May, Your Lordship, when I appeared before the medical doctors, Your Lordship, there I was found, my vision was 6/12, Your Lordship.
Where do I get that?
Yes,
Your-
32. Let's take out this proper.
Declared fit.
This is the Form 3 certificate, Your Lordship. This is after I had undergone LASIK treatment, Your Lordship.
Oh, it was 6/12,
Yes, Your Lordship.
distant.
Yes, Your Lordship.
Then refractive surgery. Then 6/6 it became.
Yes.
So the 34 refers to 6/12.
Your Lordship.
Defective distant vision. This refers to the earlier period,
Yes, Your
page
Lordship.
34.
Page 34 is post LASIK treatment, Your Lordship.
No, defective distant vision refers to the earlier
Yes,
period.
yes, Your Lordship. Yes, Your Lordship.
What appears, my lord? In the first examination, she was declared unfit because of 6/12, my lord. Then she went for surgery. Then he asked for a review, my lord.
Okay.
May I only refer to one paragraph in my affidavit filed before the London Single Judge, my lord.
Okay. Anything else?
Well, only that aspect. Well, page 157, Your Lordship, kindly. For a moment, well. 157 and 158, well. Well, 157 is the first medical examination, well, dated 4th of May 2018. Date here at the bottom, well. And there she was 6 by 12, 6 by 12. Thereafter, she went for surgery, my lord.
And became 6 by 6.
Then became 6 by 6 and then asked for review medical examination, page 158, my lord. This is dated 8/6/2018.
Yes, this is 156, that is page 30, 32, 34.
My lord. This is a better, fairer copy, my lord. Yes. But another question that may arise, my lord, on the first medical examination is admitted position that she had 6 by 12, my lord. The review medical examination is only to find out whether the examination was done correctly or not, my lord. What she does, she goes for surgery at that time, my lord. After that, then comes back and then asks for review, my lord. Changes her situation, my lord, and asks for
That is entitled to do.
review. Then the purpose of review in my humble is lost, my lord. Review is only to see whether that examination was correct or not.
How will you see? After the patient has started, the patient is not there, what will you review?
My lord,
Whether the machine was functioning correctly.
no, my lord, the whole purpose of review is that first medical examination, there should not be any error of judgment, my lord. That is the only purpose of review medical examination, my lord. It is not to enable somebody, my lord, to go for surgery or do some kind of treatment and come back for review, my lord. I'll leave it to discussion, my lordship, my lord. But she's also not been very fair, my lord, in the entire thing, my lord.
It's a meager post of a nurse. Like how much labor she has put in. Advertisement, application, these bulk of papers to be filled in, medical examination, organ by organ. Then they come to eye. First they say it is fit, then they come to eye. Then unfit. Then she goes and does the surgery so as to become fit. Some acknowledgement of this effort also should be made. They're trying her best to become fit for service.
Yes, Your Lordship.
Anyway, we will see.
My lord.
We will see without disturbing the whole selection
My
process.
lord, my lord. And also without disturbing the rules, my lord, because
Yes.
and that direction, my lord, no one will be appointed without she being appointed. That's the third direction of the learned.
No, it's a policy. We will say that you disapply, subject to my brother's
My lord,
concurrence,
my lord.
disapply this kind of a requirement with regard to nurses.
My lord.
Provided they can see with glasses of reasonable power,
My lord.
not plus 12,
My lord.
up to, as they have said, 4.5, 5, etc.
My lord. More so because they're appointed at the young age, the power condition is like that, my lord, and they have to serve for 20, 30 years. So it should be reasonable, my lord, to
Reasonable, and again, if you insist too much on that,
my lord,
you will be hit by the Disabilities Act.
my lord. That's true, my lord.
Person with hearing impairment, eye vision,
But we are exempted from Disabilities Act, my lord.
exempted.
My lord.
No,
Paramedical
but
force are exempted.
this particular part of the service may not be nursing.
Entire force is exempted, my lord.
Sure,
My lord.
all posts.
All posts.
All right, please. Hearing concluded, CAV, advocate on record for each of the parties is at liberty to file written notes of argument with the master attached to this court by 25th June. 1 week.
Oblige, Your Lordship.
Number 2.
this case properly. Yes, please.
May it please your lordship.
Yes.
Milord, it's a we've come before your lordship with a writ appeal
Yes.
with an application for condonation of delay.
What is the length of delay?
287 days. Milord, at this stage, Milord, I would just pray that notice may go. Milord. There is a private respondent. State is
The dispute
respondent.
is with the private respondent, my lord. So state will be a formal party here, because it's the issues with regard to tenancy, my lord. So they would be like to have a say on the delay, my lord.
It's a writ appeal. From
Writ appeal.
A judgment order of a learned single judge.
Right, Milord.
All right. This is a writ appeal. Next, it is from a judgment and order of a learned single judge in a writ petition. Next, the appeal is accompanied by an application under Section 5 of the Limitation Act 1963, for condonation of 188 days delay.
287, Milord.
Condonation of delay of 287 days. Paragraph. At this stage, let service of this application be effected on the respondent and an affidavit of service filed before the returnable date. How much time, Mr. Chakraborty, you will take to serve?
Oh, 1 week, 1 or 2 weeks, Milord.
2 weeks.
2 weeks.
List the appeal along with the application. On 3rd July,
My lord, notice will be for respondent number 2. Notice will be for respondent number 2, my lord. I represent respondent number 1.
What my friend is submitting is that
yes. After that, you write the double date. Before the date is fixed, huh? You write learned advocate appearing for the respondent number 1 agrees to accept service
My lord.
on behalf of our client. Full stop. Therefore, let service be effected upon her. All right.
My lord.
highly realized.
Number 3.
Yes, please.
Please, my lordship, this relates to the National Highway 6, my lord, Joy Ratachara, my lord.
Yes.
Where we had undertaken to repair the entire stretch of 102 kilometers, my lord. My lord, due to the persistent rain, my lord, progress of the work is not much, my lord. So we are seeking some more time, my lord.
Rain is usual, and rain is only started in the last few days.
My lord, we have prepared in the meantime prepared a status report, my lord. So I am praying, my lord, that the status report will indicate that we are making all efforts, my lord. And if my lord is pleased, my lord, we may be allowed to take an extension of another 2 months, my lord, minimum. I would.
There will be more rain in the next 2 months.
My lord, if I humble pray, in terms of the last order, my lord, which I had pointed out, if my lord, the respondent can file a short report
My lord,
indicating,
the
my
status-
lord, indicating the
report
present
is ready, my
status, indicating the present status and the status, my lord, which they have, my lord, not attended.
My lord, I have prepared a small status report, my lord. I may be allowed to place my. I did not file any affidavit in the form of affidavit, my lord. Only a status report.
How much is complete in the first sector of 51 kilometers?
My lord, 75% of the work has been completed in the first stretch, my lord, and in the second stretch, my lord, around 80%, my lord. Page 3, my lord. Page 2 and page 3. my lord.
Second stretch is 51.255.
Yes, my lord. 51 kilometers. Joy to YJL. Page 2, my lord. So I'm praying, my lord, with an expectation that weather condition permits us, my lord, we will make significant progress, my lord. So we cannot promise that it will be completed within the next 2 months also, but we will try all our level best, my lord, to make significant progress, my lord.
No, this we will say must be completed.
My lord,
Then thereafter, if you cannot, you come up with an application for extension. Otherwise, the moment we say that try to complete or as preferably within 2 months, so it will all go.
Absolutely, ma'am.
my lord will kindly
We will record your submission, Mr. Sengupta.
My lord will kindly grant us 3 months time, my lord, and thereafter, my lord, if we fail, we'll come by way of an application for extension of time, my lord, with
Ma'am, the road condition is terrible, my lord.
I want to see this completed before I go from here. So 3 months will be too long. Okay. So let it be 2 months. Try to do it. Please take down. Order dated 16/4. First paragraph. Then third paragraph, box portion only. Then when the matter was last heard by us, in the first sector of 51 kilometers, 67% of the work and in the second sector of 51.255 kilometers, 73% of the work had been completed. After 67%, no need of writing of the work. 67%, and in the second sector of 51.255 kilometers, 73% of the work had been completed. Next, on 16th April 2025, we had noted the above and had adjourned this application till today. expecting a completion report. However, Mr. Showman Sengupta, learned advocate for NHAI, has filed another report in this court today. It is taken on record. He submits that in the 51-kilometer sector, 75% of the work has been completed. And in the other sector of 51.255 kilometers, 80%, 75 and 80.
Yes, my lord.
80% has been completed. Full stop. He says that because of bad weather, the work could not progress as speedily as promised when the matter was heard last. Full stop. He prays for further time to file a completion report. Considering the submissions made and submissions made and also taking into account the present weather conditions, we grant time to NHAI till 18th August.
If my lord allow me to point out certain, my lord, in the certain things in the report.
What?
Madam, kindly come to report dated 10/4/2025, the earlier report which was filed by the NHI.
Yes.
Madam, kindly just see the stretch of work undertaken. My lord has the report, my lord. And
What you want to say?
my lord, here on the report filed dated 10/4/2025, my lord, the work undertaken under first head bituminous concrete, it was 29 kilometer. Now they have shown as 32 kilometers. And here in the second, dense graded bituminous 32 kilometer, here also 32 kilometer, my lord. So which shows, my lord, there is no substantial work as in done.
As MI6 query, you are supposed to go to the site and give a report to the court. You cannot be a parallel counsel.
My lord, I'm not, my lord, I'm not doing
you
that.
go to the site and give a report.
That will do, my lord. That will
Please do. Don't do all these
Here, my
things.
lord, comparatively, my lord,
That we will
this report would
take
show
care
that no
of.
substantial work have been done.
That
That's what I'm
we
trying to
will
point
take
out.
care of.
My lord.
You will not go to the site, not do anything and
On the last time, on the last occasion, I had submitted the
we are
report.
giving
my
them
lord.
time, they will do it. Finish.
We'll do it, my lord.
Eighteenth August to file a completion report. The amicus curiae is directed to closely observe the progress made and file a counter report if necessary by the said date. list this application for further orders on 20th August.
Yes.
Number 4.
Yes.
May it please, Lordship. Lordship, as per the last order, Lordship, we have filed an affidavit today morning, Lordship. And the affidavit, Lordship, is on board, Lordship.
My Lord, I, the petitioner, on behalf of the Sangasi Mountain Ram, I raise my objection about the jurisdiction of the District Council Court to try a case interrelated with our society. Because as District Council Court, as per the administrative rule, should be try a case only for a tribal, as mentioned in the President Notification 1950. As the
I'm appearing for respondent number 16 in this case. I just want to apprise the court that the proceeding in the district council court, they have passed an ex parte order against the PIL petitioner, Your Lordship, because they never appear. Several time a notice has been issued to them, but they never appear, Your Lordship. It's there in the affidavit which we have filed.
Page 121.
Page
121.
121, Your Lordship.
My Lord, the case also is against me in the council, not against the society. Personally, because as per Society Act, no case should be listed with the suit of the society, no case should be against the individual of the or the against member. The case of the society should be against the society. The case also, any case related with society as per the section 2A of the Society Act should be fall under the principal civil code of the regional jurisdiction of the district within which the register office of society is situated, not in the subordinate court. Because the land, as per the MFC, also the land is not belong to me. It belong to the society. It's already registered also in the revenue department. The land also fall in the revenue department, not fall in the district council. How the district council interfere the affair of the 7th schedule? Because the land is fall under the 7th schedule and the concurrent list in the item number 6. Because this land is registered under the central law under Registration Act 1908.
Your Lordship, the MOU that they are referring to, they have registered it like unknowingly. So we don't know anything about it. We are not aware of it, Your Lordship.
If the CM or they say that he's not doing anything, I request the Honorable Court to issue a forensic whether the CM is signed or not the signature. Everybody who made an allegation before the court should be punished as per the rule of law.
That's it.
Let us see whether a PIL lies, otherwise we will dispose of and say that the child will be. You are ready to argue the matter regarding jurisdiction?
Lordship, actually, Lordship, today the leading senior counsel who is leading this case, Lordship, he's on bereavement, Lordship, and he'll be returning tomorrow, Lordship. So I'm requesting, Lordship, if this matter can be listed next week, Lordship, then...
But what ex parte order has been passed?
Lordship, the ex parte order has been passed in the district council court, Lordship, because of the fact that the petitioner here has not appeared, Lordship, despite of many services affected.
What ex parte order has been passed?
Lordship, the ex parte order is at page 121. Lordship, may kindly have it. If I may read, Lordship. Plaintiff is present and File Hazira, defendant and proportionate defendant are absent. Heard learned counsel for the plaintiff. The suit shall proceed ex parte against the defendant, and the plaintiff shall take steps with regards to the ex parte evidence on the next date. This is the latest order, Lordship.
Sir, my lord, I already challenged his
If you have any
jurisdiction.
grievances, Lordship, he could have come, Lordship, at least.
Notice also is issued.
No order has been passed.
No order, Lordship.
Only
but this is-
procedural order.
Yes, Lordship. The order to proceed ex parte, Lordship.
All right.
Because you have no jurisdiction.
When you will do the matter? First, the jurisdiction of the court to hear PIL
Yes,
will be
Lordship.
considered, and if we think
Lordship.
that the district council prima facie has jurisdiction, we will refer the matter to the district council to determine its own jurisdiction.
Because it seems there's a disputed question of facts also, Lordship.
So the matter is passed, this expert judgment after the court is.
If we find that they have jurisdiction, we will not usurp that jurisdiction.
Absolutely. Lordship.
But if he wants to challenge that jurisdiction, he
Yes.
can do it under Order 7, Rule 11, whatever he likes.
Absolutely. Lordship. So, Lordship, if I may pray, Lordship, this matter can be listed next week, Lordship.
Yes.
Anytime,
But in the meantime, don't take steps before the council.
Lordship, as far as this order is concerned.
You are appearing for
And for respondent 17, Lordship. The headman,
17 is,
the headman of the Dorbar Mausan Ram, Lordship.
he is the main respondent.
No, Lordship,
No,
the
I am the main
respondent
respondent.
16.
16. I'm for the office of the scheme.
You are also praying for time?
Yes, Your Lordship.
When should we keep it?
Next week, Your Lordship.
All right. List this public interest litigation on 26th June. On the prayer of learned counsel for respondent number 16 and 17. List this public interest litigation on 26th June to determine first the jurisdiction of this court to hear this public interest litigation, and secondly, if jurisdiction is found to be vested, to pass appropriate orders in the matter. Paragraph. In the meantime, the district council is not to proceed with the proceedings before it except in case of very urgent requirement, when the district council may proceed after leave is obtained by one of the parties from this court. You keep that thing open. Is any other matter?
Thank you, my lord.
Deeply obliged.
Yes.
Number 5.
Yes, please.
This come for hearing today, my lord.
Proceed.
Yes, my lord. I've got small list of dates, my lord. Dia na.
My lord, just before I go ahead with the argument, the issue, let me just place it so that it become easier for my lord. The letter of acceptance was issued by the FCI to the appellant in respect of some transportation of good fruit grains and other materials from in Tripura, my lord, state. So LOA is issued to the appellant. There are certain conditions that he will deposit, security deposit will make, this and that. Appellant, because certain reasons, did not deposit that one. So they took a penal action. The penal action was termination of the contract, number one. Number two, debarment for 2 years. And number three was the work will be placed on the other contractor at the risk and cost of the appellant. These are the three issues. Now, so for the single judge is concerned, my lord, the 2 years has passed by now. Whatever they put the condition, that has almost passed. So the termination, it's okay. It has gone, my lord. Now remains risk and cost. So in that regards, my lord, they may take a first lordship, my lord, may kindly take the list of dates, my lord. List of dates. My lord, 29/2/24, the judgment was passed again, which I before lordship, my lord. 7/8/23, NIT was issued. My lord, NIT was issued, and 28/8/23, I submitted my bid. My lord, the tender value was 7 crores. The petitioner is a woman entrepreneur, my lord. This is the second tender. She was inexperienced. She quoted, my lord, 4 crores. The value was 7 crores. There's a mistake she has committed in the calculation because that's the new formula they have adopted. So, my lord, she has written to them that there's a mistake. So, for adjustment other things, my lord. Ultimately, my lord, they found the INDL1, they issued LOA, which is lordship will find, that's in page number, my lord, 140, my lord. Page 140.
Eleven 1/2023,
My lord.
page 2 of your list of dates.
Yes.
Who issued this order? Impugned order?
Impugned order of the FCI, my lord. FCI.
Is there an arbitration clause?
There is an arbitration clause, is not, my lord, that way, but
So there is not an arbitration clause, but there is a GRC clause, grievance redressal committee, my lord.
Oh, that is useless. No arbitration clause.
no arbitration clause. And there's a lordship's judgment in Calcutta High Court Division Magistrating.
What judgment?
Your lordship's judgment, my lord.
So,
Yes. This is a beautiful judgment, right? Rupa and Company Limited, my lord, versus State of West Bengal. And lordship was sitting with Honorable Justice Nizamuddin, my lord.
this is reported also.
Yes, that's all.
Reported also.
Listen, my lord. Lordship, my lord. Yes, sir. This in page number 9, my lord. If a lordship come to page number 10, my lord, top. Bottom, page marks are at the bottom, my lord. Bottom, and then the contents from the top, my lord, 6th line. 1, 2, 3, 4, 5, 6th line. Page number 10, 6th line. Now it is oral settled that if a public law element is involved in a commercial transaction between the parties, dispute can be resolved by evidence. The court may exercise discretionary jurisdiction under Article 226.
That is all right, but here question of damages arises, taking of evidence.
So, my lord, that part is concerned, evidence is concerned, my lord, that they will may file a civil suit for that, my lord, that issue. The question of law involved here will be, my lord, the two issues. One is, as held in Nazir Ahmed case, my lord, in 1936, when lordship is known to lordships, my lord, just reminding, when certain
yes, to be done in a particular
Yes.
manner, it will be.
Here what has happened, my lord, what they have done. Please come to page number 46, my lord. Page 46. 46. My lord. 46 paragraph 2, my lord. Page 46, paragraph 2 in the middle. In the middle, paragraph 2, my lord, highlighted part, my lord, bold letter. However, the successful tender are in the middle, my lord. Let me read this one. This is the important part. However, tender should be uploaded, submitted through general portal, manual bids. Hard copy of the tender would not be accepted. However, the successful tenderer will have to submit the original hard copy of the MTF, duly signed on each page of MTF, along with annexures appendices, duly attested on or before the date and time stipulated by the FCI. So first thing, my lord, I have to submit those MTF. Failing which, if I don't do this, my lord, lordship has got, my lord, page 46, my lord.
Yes.
My lord, in the middle. Failing which, the EMD furnished by the bidder is liable to be forfeited. And further, the award of contract through the letter of acceptance will be issued to the successful tenderer only after he fulfills this requirement, my lord. Here your lordship will find this clause they have given complete go by, my lord. Because initially what happened, my lord, when I quoted the minimum price, 4 crores, my lord. So I wrote to the MSC, Ministry of Micro Industries, my lord, because I am also registered under them, and I was exempted from EMD. So,
What were the prayers in the writ petition?
Yeah, my lordship can develop. Page number, my lord, 40. 40. 40A, my lord. Impin order dated 15/11/23, my lord. Issue with response number 3.
Did you start performance under the contract?
No, what happened? When the work was LOS issued, my lord, the work was supposed to be started from 3/12/25 to 2/12/25. And the work order issued to me on 20/10/23. Before that, work did not start. It was supposed to start later on, my lord. That is from 3/12/25, 3/25 to 2/12/25, my lord. That's that. So subsequently, this has to be started. Now the cost and risk and cost comes, my lord. They said it is for the unexpired work. Work has not even started. It was to be started after 2 months, my lord.
Now has the work been given to somebody else?
Yes, it was given to somebody else, pursued a tender, my lord. So
he has started the work.
He can say, my lord, he's starting the work.
Completed.
No, my lord, it will be completed by the end of this year, my lord.
It is proceeding.
Yes. At his risk and cost.
What was the work?
My lord, for transportation of food grains from the railhead to the FSD, my lord, food storage depot of the FCI, my lord.
There's a gap period in between when the work is issued.
So the writ was entertained by the court. By this court, it was entertained.
Yes.
My lord, learned single judge has, in fact, there was two component of the termination letter. One was the terminated, his contract was terminated at his risk and cost, and secondly, it was debarred for 2 years. Before the learned single judge, my learned friend has argued that debarment should be caused because it has no so cause was given, and it was rightly been set aside, my lord. And so far,
blacklisting. They call it blacklisting.
Yes, my lord, blacklisting.
Yes.
So far as termination at his risk and cost, my lord, my learned friend has not argued, my lord. Now he has turned around and saying that the learned single judge has not taken into consideration of his second argument, that is, it should not be at his risk and cost. I will just point out the judgment of the learned single judge, my lord. It is at page
You see, there are two prayers usually in such a contract.
Yes, my lord.
He will claim damages
Yes.
for wrongful termination.
He may file a
And
civil
of
suit.
course, if he gets damages and breach on your part is proved, there is no question of any risk purchase damage. And you will counterclaim
My risk and cost.
your risk and cost.
Yes, my lord.
So these issues were not there before the writ court.
In fact, my learned friend has not argued, my lord.
Only blacklisting was argued.
Yes, my lord. I'm just pointing out at page 244, it starts, the judgment starts. At best, my prayer would be that he should file a review petition if the learned single judge has not taken into consideration, my lord. My lord, just page 248, my lord. I will take 1 minute only. Paragraph 5. Paragraph 5 of the judgment, my lord, page 248.
Yes.
Yes, may I read it, my lord? Having heard the learned counsel for the parties and having perused the materials as placed, it is first noted from the submission that the petitioner is more aggrieved with the debarment for a period of 2 years, which has been argued to be the same penalty as one of the blacklisting. So he has not argued what my learned friend is now placed.
And the writ has been allowed.
Writ has been partly allowed. That setting aside the debarment order, my lord. And that termination with at his risk and cost is still there, my lord. So it is wrong on the part of the petition, the appellant, that the learned single judge has not considered, my lord.
It was 226.
What do you say?
My lord. Please come to, my lord, first of all, page number 246.
No, this will take time because some intricacies are involved. You have not taken the point now for the first time in appeal.
My lord, when I challenged in paragraph 15 of my writ petition, very clearly have stated about the risk and
That
cost
will not
factor,
do.
my lord.
The Supreme Court has said, and it is also very trite law, that if you do not take a point, taking it in your pleadings will not do. If you do not take a point before an arbitrator or the court, it is deemed to have been waived.
My lord, kindly just have a look once, page 146.
My one of that argument is there, my lord.
246. He submits that me that subsequent action in terminating the contract by an impending order dated such and such, and at the same time debarring. This thing I have covered, my lord. Although in a very specific word, but this is submission recorded here, my lord. And also in page number 226, my lord, kindly see. Interim order was passed very specifically, my lord. There has been stated. Page number 226, order dated, my lord, 16/12/23. That says, it has been submitted by the learned counsel for the petitioner that impending order has been passed without affording the petitioner an opportunity to bring her. As such, he praised that impending order dated 15/11/23, whereby the petitioner has been held liable to cover the risk and cost of the corporation in the fresh is stayed in the interim. That is there, my lord. And also, my lord. Number 2, my lord. As your lordship is held, my lord, writ appeal is a continuation of the writ petition, my lord. So probably lordship will allow me to ask that point, my lord. That Bangalore refinery of Supreme Court case, my lord, celebrated case, my lord.
We have waived that right.
That, my
For
lord,
the first time in appeal you will raise.
page 46, my lord, kindly just have a look once.
My lord, if necessary, I will bring on record by way of filing an affidavit that the appellant has not taken that point at the time.
What
of the
further relief you want?
My lord, so for terminations contract, I'm not paying for anything. 2 years debarment is gone. Only parties, when these conditions provide that cost and expenses for the unexpired period, my only submission is, my lord, the unexpired period, suppose if I start working from this wall to this wall, I complete half, I go out, I don't work. The rest of the portion, it was given to Mr. B. Then this part will be, my lord, risk at my cost. That is true. Here work has not been started. It was a subsequent period for the, my lord. 2 months were there, my lord. Ahead it there. Works to be started, my lord.
The concept is not that. Starting, finishing is not the issue. Suppose there is a contract that this work will be done for 100 rupees in 2 months. You don't even start the work. No question of starting, progressing, nothing of that kind. You don't even start the work. So what will the other party do? He will cancel the contract, terminate, repudiate, rescind the contract. And you are A, he will give it to B. When he gives it to B, we will say, yes, I will start and finish for 125 rupees. That 125 minus 100 is the measure of damages which you have to pay him.
25 rupees.
My lord,
Exactly, my lord.
my lord. Suppose, my lord, if lordship is fine, the issuance of LOA is in violation. This is the legal question. As I said, Nazir Ahmed, suppose lordship is fine, they have not followed the one, they imposed their data fiction to me, my lord, in spite of having knowledge. Probably lordship will consider that part. I will humbly submit, my lord, consider that part. Because when they found me I am L1, they are supposed to inform me, as per the tender clause, please furnish these documents, MTF duly signed. After I sign it, then they issue a
So
LOA.
your contention is that you have rightly repudiated the contract and left.
Yes, yes. From the beginning, I informed them.
So that they cannot claim any damages from it.
Exactly.
All right, when do you want to do the matter? It cannot be finished today.
My lord.
When you give a date.
My lord, next
July.
July, there are some holiday and other things.
My lord, August, first week or second week, my lord.
No. August is too long.
My lord, July last week. We are having 2 weeks holiday, my lord.
Holiday and
Summer
then-
vacation. We are both from Guwahati, my lord.
Summer vacation in July,
Yes, my lord.
not in May, June.
No,
Not
in
in
July.
All right. So when?
Second week of my lordship, any day lordship may choose, my lord.
July.
July, August. August, because my lord, there will be some problem. In July, lordship goes into
Yeah,
we get once. Once the holiday that
No. Wow. What is the length of your holiday?
It's of
2 weeks, my lord. Up to 13, my lord.
20th up to, I think.
20.
20th.
When to when?
21.
20th. My
21 is Monday.
You must know your calendar.
No, I have got the calendar. My lord, it is just after the holidays in Guwahati High Court, my lord. So little matter, 1 and 2 matters. We have.
No. When is your holiday? Just after the holiday?
Holidays is, my lord, up to 19th, up to 20th July, my lord.
From when?
From from first. Yes, from 1st of July, my lord.
1st of July to 20th July.
Yes. It will be 19th. Basically, it will be 17th, but 18th is a Saturday, and 19th is a Sunday, and 21st is a Monday. That's why.
All right. When you want it?
Yes, my lord.
August.
21.
4th August.
4th August, my lord. Oh, that is also fine, my lord.
5th August, my lord. We will be comfortable very much if your lordships can provide that date.
All right. Arguments in this appeal have commenced, but not concluded. By consent of learned counsel for the parties, considering the ensuing summer vacation in the Guwahati High Court, no, you cut that out. Considering the ensuing summer vacation in Guwahati High Court, both learned counsel have agreed for fixation of this matter on 5th August. Paragraph list accordingly.
Just like that.